It says 30 years ago, a lawyer filed a motion to reopen an INS I-30 decision, and voluntary departure was offered without hearing. The lawyer failed to let the client know. 30 years later, the client found out through a FOIL.
Well, I think you should do a second motion to reopen. So this happened 30 years ago. So was that 1988?
Yes.
So in 1988, they were calling it orders of deportation. Now they call it orders of removal. If you're lucky, it was 30 years ago, because on an order of deportation, you're allowed multiple motions to reopen. So if this lawyer screwed up a motion to reopen and you have a constitutional right to reopen your case, you're allowed to keep filing motions to reopen until you get it right. In 1996, when they changed the laws and they now said when you're in deportation, they're now calling it removal, you're only allowed one motion to reopen. So if the lawyer already exhausted that, you would have a problem. Luckily, if I'm doing my math right, this happened prior to 96. You can do multiple motions to reopen. You should be coming into my office, bringing this FOIL, same thing, into my office. Let's review it and figure out what happened.
And Fox Racing also just wants to add that this person that didn't know that he was offered voluntary departure still lives in the USA for 35 years.
Sure.
Good moral character, pays taxes, no criminal
Fine.
records.
And there's no bar to making a motion, again, no bar to making a motion to reopen from something that happened 30 years ago. The laws changed in 96, so it's much easier for cases that were pre-96.